Thousands of people in the UK are admitted to hospital each year with dog bites, according to the Royal College of Surgeons. Treatment is the priority, of course, but can you also claim compensation? In this video, I'll explain about a dog owner's legal responsibility for dog bites. You may be familiar with the Dangerous Dogs Act of 1991, which makes it a criminal offence to breed or sell 4 specific dog breeds in the UK, and it bans dogs from being dangerously out of control. But in this video, I'll be looking at the civil law, the Animals Act 1971, and the law of negligence, which could underpin a claim for compensation. I'm Barrister Daniel Barnett, a barrister practising in London and presenter of the Legal Hour on LBC Radio. If you haven't done so already, please do have a quick think about subscribing to this channel and particularly giving a thumbs up to this video. It helps other people find similar legal explainer videos that can be of great use to them. Although this is primarily about the civil law, meaning an individual suing another for compensation rather than the CPS prosecuting a crime, a good starting point following a dog bite is to report the matter to the police. Some people won't be worth suing because they have neither pet insurance nor the money to pay. In those circumstances, the police will at least be able to investigate whether an offence has been committed under the Dangerous Dogs Act, which may prevent future incidents. And the evidence they gather may of course help you if you do end up making a claim, which is most likely to be under the Animals Act. To claim under the Animals Act 1971, you'll need to prove 3 things set out in Section 2. First, that the dog, unless restrained, was likely to cause injury, or any injury it did cause was likely to be severe. Now, because dogs' jaws are powerful and their teeth are adapted to puncturing skin, the court is very likely to accept that any bite injury is likely to be severe, and an owner or keeper or their insurance company will often concede this point. Second, you'll need to show the likelihood of the bite was due to characteristics not normally found in dogs except at particular times and in particular circumstances. So it must be in character for that particular dog to bite in such circumstances. For example, when defending territory or if frightened by loud noises. Finally, and this is probably the most challenging part of any claim, you'll need to show the dog's keeper was aware of these characteristics. Now, this also applies if a child from the same household or an employee was looking after the dog at the time. It can be difficult to prove what someone did or didn't know, but any evidence of the dog's previous aggression would be helpful in this regard. It might be worth speaking to local residents and dog walkers about what they know of the particular pet in question. And if you can't gather any direct evidence, you might be able to rely on dog guides, on breed manuals, and internet forums to demonstrate what an owner would be likely to know. What matters is what the owner knows, whether that knowledge comes from experience of the dog's past misbehaviour or a general awareness of the breed characteristics. Even if you can establish these points, the owner may have a defence still. The defences against any claim for compensation are set out in Section 5 of the Animals Act. You won't succeed if the bite was your fault, if you accepted the risk of being bitten, or if you were trespassing. So, for example, if you were provoking or antagonising a dog, that might make it your fault. And in the case of Dhesi against the Chief Constable of West Midlands Police, a suspect refused to come out of a hiding place, having been warned that a police dog would be sent in. He was bitten, but it was ruled he'd accepted the risk. If you were trespassing, your claim will fail unless the dog was being kept for the purpose of guarding the property and it was unreasonable for the dog to have that purpose. Now, although the Animals Act is the normal piece of law that people use to sue for dog bites, there is an alternative. To prove negligence, you need to demonstrate the dog owner owed you a duty of care, that that duty was breached, and that you suffered injury as a result. Now, it's obvious that dog owners owe a general duty to other members of the public, and this was established in the case of Whippey against Jones, where a Great Dane off the lead jumped at and injured a runner. Failure to control a dog is likely to amount to a breach of that duty, although the legal test is whether a reasonable person would have anticipated that injury might be caused and whether they'd taken reasonable steps to prevent potential harm. There is some level of crossover with the Animals Act because a negligence claim will hinge on what the owner may have known. If the bite was totally out of character for the dog, and the owner couldn't have anticipated it, then it's less likely they'll be found to have been negligent. So if the incident is as much a nasty surprise for the owner as it was for you, then your claim, I'm afraid, is more likely to fail. The Limitation Act 1980 requires you to start any legal claim within 3 years of the bite. If you don't know the identity of the dog's keeper, the clock starts ticking from when it's reasonable for you to have found it out. I hope you found this video useful. You might also be interested in this video. I'm Barrister Daniel Barnett. Please do like this video. I'll give you 4 seconds to do it if you'd be so kind. 4, 3, 2, 1. Thank you so much for watching. Bye bye.